Major breaking news, a huge win for the Gun Owners of America and the Silencer Shop Foundation and other plaintiffs in the case involving whether or not the National Firearms Act as applied to short barrel rifles, short barrel shotguns, and suppressors is constitutional in light of the One Big Beautiful Bill. Major win, a battle, not a war has been won, but a battle has been won against the ATF. And you need to win battles before you can win the wars. The Gun Owners of America just won a big battle, which we will cover in 1 second. In the meantime, do not forget this afternoon, folks. This afternoon, I got the 4 Boxes Diner Halloween special. You're going to want to tune in and check that out. And of course, I hope you enjoy my my Colt 45 jersey I'm wearing for Halloween. And we'll see if you guys can connect it up to this case down there in Texas by the Gun Owners of America and my Colt 45 jersey. All right, we'll be right back. Hey folks, I'm Mark Smith, host of the 4 Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and proud to say the top voice of the Second Amendment in America. Thank you, 2025 Gundies Awards. All right, big win for Gun Owners of America. And it's kind of interesting because these are little wins in one sense, but they're big wins in the big picture. It's like a football game or a sporting event. You got to win a lot of little plays to score to win the game. Well, the Gun Owners of America and Silencer Shop Foundation and other plaintiffs in a case involving the NFA and short barrel rifles, short barrel shotguns, and suppressors just won a big battle in their fight to knock out these items from the NFA entirely. So as you may recall, Gun Owners of America and Silencer Shop Foundation and related entities brought a major lawsuit in the United States District Court for the Northern District of Texas in front of Judge James Wes Hendricks, a Trump appointee. And in this, they basically argue that Congress lacks the authority to require the registration of suppressor short barrel rifles, short barrel shotguns, and any other regulations on them, because the only theoretical legal authority that Congress had to put these items under the National Firearms Act was a decision to tax them. And because of the One Big Beautiful Bill pushed through by Donald Trump, the $200 tax from the 1930s that had been applied to suppressors in the short barrel rifle, short barrel shotguns went away under the One Big Beautiful Bill when it was enacted through the process of reconciliation. Well, once that tax went away, the authority to regulate these types of items also went away because, as you know, under our Constitution, we have 3 branches of government. And the first branch of government is the Congress, the legislative branch, governed by the authority set forth in Article 1 of the U.S. Constitution, which sets forth a series of enumerated powers that Congress can act upon. And if it's not in an enumerated power, the Congress cannot act. Well, since 1934, Congress has asserted its Article 1 taxing authority to justify its $200 tax on suppressors and short barrel rifle items, short barrel shotguns, short barrel rifles. Well, guess what? That tax has gone away. So the question becomes, under Article 1 of the U.S. Constitution, which provides authority for Congress to legislate, where does Congress have the authority to require the fingerprinting and registration of these items once the taxing power goes away, which it now has, because there's no tax on these items? And the reason why you had a registration requirement and the reason why you had a fingerprinting requirement is to ensure that the tax had been paid on that particular suppressor, on that particular short barrel rifle, on that particular short barrel rifle, shotgun. But once that tax went away under the One Big Beautiful Bill, there's arguably no more legal authority to require Americans to get fingerprinted and or register these items, because the legal hook is now gone. There's no taxation. And because there's no tax, there's no argument for having these registration requirements, which were all designed to make sure that the stamp tax was paid on these items. But no tax means the mechanism to ensure the tax was paid becomes nugatory, moot, irrelevant. Pick your word. So what just happened is this. Obviously, the Second Amendment plaintiffs, including the Gun Owners of America, want to push this case forward as fast as possible. Why? You know why. Plaintiffs who sue usually want the case to go as fast as possible because they want to win the case. The defendants often want to go slow. They want to drag their feet and make the case go on forever and ever and ever. But here it's kind of an interesting dynamic because Gun Owners of America and Silencers Shop Foundation and these other plaintiffs sued the ATF, the federal government. So the lawyers for the ATF filed a motion, and here's the big win. They filed a motion saying, hey, we need more time. We want to pause this case because the federal government has been shut down, and we're not allowed to work on this absent an emergency. Well, I'm happy to report that Judge Hendricks read the relevant documents and said, look, I'm denying that motion. I'm going to force the federal government to go ahead and defend this law or lose fast. That's right. The federal government's either going to win or lose, but whatever happens is going to happen with speed. And the judge says to the federal government, go ahead and file your brief. You've got to file your brief because here's the interesting part. Under the rules of the shutdown, the lawyers for the Department of Justice don't have to work unless there's an emergency. And one emergency as defined by the relevant rules is if a judge requires a civil lawyer for the government to file a motion to otherwise act in a case. So Judge Hendricks was well aware of this. He also knew that the Gun Owners of America wanted this case to move forward with speed. And what did Judge Hendricks do? He kind of did the right thing here and said, hey, you government lawyers, I'm ordering you to litigate this case. And because I'm ordering you to litigate this case, there's now a court order in a civil matter requiring you to litigate the case. And as a consequence, you attorneys now fall under the rules that permit you to do work on behalf of the federal government in this case. In fact, what's quite interesting is the judge specifically mentioned that this case involved the Second Amendment, and that's a very important issue in American life. So it seems like Judge Hendricks recognized the importance of the right to keep and bear arms and the fact that this touches fingers with it, although technically speaking, you could argue this is simply a sort of a taxation, commerce clause, Article 1 case that doesn't specifically deal with the Second Amendment. He kind of thought that the Second Amendment is implicated here, and as a consequence has ordered the parties to move forward forthwith to litigate this case with speed. This is a major win for Gun Owners of America because the government was basically saying, we don't want to litigate this case until the government turns back on, and Gun Owners of America is saying, no can do, we want this case resolved quickly because we're going to win this case, we're going to kick the government's butt, and we're going to knock out the NFA. And every day the NFA continues, as applied to suppressors, as applied to short barrel rifles, as applied to short barrel shotguns, is illegal. Not only under the Second Amendment, but in particular under Article 1, because Congress is now acting, and this statute is now being enforced by the federal government, and it's unconstitutional. It's ultra vires. It exceeds the legal constitutional authority of the Congress, and thus it cannot be enforced moving forward. And that is exactly what Gun Owners of America is arguing here, and they have a powerful argument. So what exactly did Judge Hendricks say in ruling in favor of the Gun Owners of America? Here's what he wrote. Before the court is the defendant's opposed motion to stay proceedings. The motion states that due to the ongoing government shutdown, the defendant's counsel are unable to work, even on a voluntary basis, except in certain emergencies. In their response to their motion, the plaintiffs cited a Department of Justice document issued on the eve of the shutdown that lists the conditions under which the department employees are permitted to work. Among these are cases where a court denies the request and orders the case to continue. Judge Hendricks goes on to say, the court now denies the motion in part. Federal government shutdowns do not typically prevent the Department of Justice's attorneys from working when a court denies the government's motion to stay. That said, the court is mindful of the need for a detailed and careful briefing in this matter, which includes a Second Amendment claim. The principle of party presentation is critical as it gives the court a solid foundation upon which to rule and prevents reliance on weak or irrelevant evidence. Well, that's fantastic news, and it is correct that the Second Amendment could very well be implicated here because, among other arguments you could make, is that because short barrel rifles and short barrel shotguns and suppressors are arms under the text of the Second Amendment, which they are, because the language of the Second Amendment reads, the right of the people to keep and bear arms shall not be infringed. And what is an arm? Well, we know what an arm is because the Supreme Court told us. If you look at the Heller case, it defines arms as anything that can be used offensively or defensively. And with respect to suppressors, there's a specific sentence in Bruin 2022, the Supreme Court said that any instrument that facilitates armed self-defense is an arm. And because a suppressor, of course, by extension, a suppressor is an instrument, it's an object, and it facilitates armed self-defense. So by definition, it too is an arm. And once these things are textually arms, the only way they can be banned or taxed or regulated in any respect is if these items are dangerous and unusual. And as you know, the dangerous and unusual standard, or sometimes referred to in part as the in common use test, arises from the historical tradition part of the text first, burden shifting to the government, historical tradition of firearms regulation part of the Bruin methodology, which is really also the Heller methodology. As a consequence of that, the burden is on the government to show that, in this case, suppressors are not in common use, that short barrel rifles are not in common use, that short barrel shotguns are not in common use. And it's going to be very difficult for them to do that. It's going to be basically impossible for them to do it with suppressors. I mean, there's millions of suppressors. So I think that, at least with respect to suppressors, that's a slam dunk. I think short barrel rifles also offers a very strong argument. I mean, how do you have protected arms that are rifles and protected arms that are handguns under Heller and not protect the middle gun, the gun that is halfway between the two protected arms? I think that short barrel rifles is pretty straightforward. I think short barrel shotguns is a probably tougher argument for the Second Amendment. I think there's a lot fewer short barrel shotguns out there. I think you also could arguably, which means there's arguably not in common use, and thus they are not common. They are arguably unusual, and perhaps you could argue that they're also dangerous by virtue of the risk of collateral damage associated with the use of them. But again, that's the subject of another video. We don't need to belabor this point now, but the point is, when it comes to short barrel rifles and it comes to suppressors, those should be slam dunk cases. They're clearly protected by the Second Amendment, period. Full stop, no different than handguns. I do think the short barrel shotgun issue is a little bit more complicated, in part because you do have the decision by Miller in the 1930s that says short barrel shotguns are not protected under the Second Amendment, kind of reaffirmation of that by Justice Scalia and Heller. But I do think that's kind of a line call in various respects. But truthfully, if we in the Second Amendment community can win short barrel rifles and suppressors of protected arms as well as AR-15s, that is a massive win. And if we have to leave short barrel shotguns on the table, in the grand scheme of things, it's a price I'd be willing to pay. Although I'm pretty much a Second Amendment absolutist, but I also live in the real world, and that's why I have to try to call it as I see it. What's really going on? It's not my wish list. It's not my fantasy world. It's what I think we can accomplish right here and right now. But again, if we put William Kirk on the Supreme Court, well, you never know what might happen down the road, but this is where we are today. All right, folks, so there you have it. Hope you enjoyed today's episode. A big win for gun owners of America. This case is pushing forward, and hopefully at the end of the rainbow is the end of the NFA. That is not impossible. Fingers crossed and candles lit. So again, make sure you follow me over there on X at 4BoxDiner. Don't forget to subscribe, YouTube, and Rumble, and make sure you watch this afternoon the Halloween special. You're going to really enjoy it.
Orders up. Table 2A.